everyone, and welcome to Daily Newspaper Analysis, which is brought to you by LawSikho. We hope that you're all doing fine and great. And today we have an editorial for our discussion. This editorial has been taken from the Hindu newspaper. The title is A Victory for Crime Victims. So this has come upon a recent judgment that the Supreme Court has given and has opined that the right to hear shall be given to victims. Now, what is it all about? What we'll be doing about it? We'll all discuss in detail in the coming article. Next, we have is the news updates, where we'll discuss the most important awards, appointments, the most important events, important dates, personalities, etc. that can precisely be asked in our prelims exam. And thirdly, we'll be covering the legal news for the day, wherein we'll be covering the latest judgments coming from the various courts of India. Before moving further, I would like to congratulate some students who have been giving the right answers in the comment sections. I would like to take names for Shivani Dinkar, Mitali Takkar, Anindo Chatterjee, Azmat Hayat, and others who have been giving the right answers in the comment section. Great going, guys, and we hope that you will be continuing this pattern, and others also, you will be continuing giving the right answers in the comment section whenever we ask you a question. With this, let's start the discussion for the day. The first article, and basically the only article that we'll be discussing today, is about the victory for crime victims. Let's see why at all this is into news. So the Supreme Court in the case of Jagjit Singh versus Ashish Mishra 2022, so this is a very, very recent judgment, as you now know, has held that the victim has the right to be heard in all the stages of the trial. Now, this precisely also becomes an important statement or important question for the prelims, as you must be noticing. These days, the questions or the trend for the prelims, the legal aspect has become too much into the latest case laws and even the general landmark case laws as well. So this is a case for Jagjit Singh versus Ashish Mishra. So it can be a question as to which of the following relates to the case of Jagjit Singh versus Ashish Mishra, and they'll give you some options. Please note that the right option would be that this deals with that the victim has the right to be heard in all the stages of the trial. So be it the beginning stage, the middle stage, or even during the end, or the, when we say the climax of the trial, even then the victim will have the right to be heard. Now, this definitely is a major win for the victims of crime and the criminal justice process in India. So when we talk about the rights of victims and the rights of accused, definitely the Indian criminal system, to be very precise, talks about various rights for the victim as well as for the accused. So here, for example, let's say for the victim, we have that they shall have the right for the allegations to be investigated, to be informed of the progress of the investigation, to be informed of their role as a witness, and so on and so forth. And when we talk about the rights of the accused, so here we can say that it not to be illegally searched, to remain silent, to apply the bail, and to have interviews recorded, etc., and so on and so forth. So all of these rights can be seen on the part of the accused as well as on the part of the victim. Let's hear. So Ashish Mishra is an accused in the Lakhimpur Kheri case. You must be remembering that there was this case wherein there was a car that ran over various people, especially farmers, and many were killed into this rampage. And Ashish Mishra is one of the accused in this particular case. So the court has held that the criminal justice system in India conflates the presence of the state rather than the presence of the victim. So it says that, there is a kind of a mix-up, a kind of a confusion that we see over here, that instead of presence of the victim, that what are the aspirations of the victim, what that victim particularly is looking forward from this one single trial, that is somehow suppressed in the coming forward cases. And rather what happens is that the presence of state takes over the entire scenario. Now, Niels Christie, who is a Norwegian sociologist and criminologist, has stated that the state assumes the ownership of the property in criminal justice when the same has to be returned to the rightful owner, that is the victim. Now, here definitely a lot of confusion is there. In the Indian justice system as well, you must know that whenever a criminal case is taken up in the case or in the court, so what happens is that the case is fought against the state, as in, here we have is an accused, and the case is then filed by the state. For example, if this accused A versus some person who is the victim, so we all know that it will be A versus the state of whatsoever, be Maharashtra, Delhi, whatever it is. Right? So in that situation also, it is saying that what happens is that it is not just that the name of the trial is in the name of the state, rather it seems like the state takes way too much of ownership into that particular trial. So the court has held that, firstly, the victim cannot be said to wait till the commencement of the trial to participate in the proceedings. Secondly, the victims are denied pre-trial rights since they are not the complainant. Now, this has to stop. Please remember that this practice that we are following, that they are not given any kind of pre-trial rights, right? Because they themselves might not be the complainant, and the state here is the complainant in this situation. This is not a good practice, and definitely because ultimately the entire justice system is to serve the end of justice for this particular victim. Now, if at all we are not able to provide these basic pre-trial rights also to the victims, just imagine what is the entire purpose of putting up the trial in the very first place. Thirdly, the right to be heard for the victim extends till the end of the appeal or revision. So it's not just, that the case has come up, the judgment is done, and thus the rights of the victims are ended, and no more will be taking care of such rights. But we will be extending such rights even if any appeal has taken place, or even if revision of this particular judgment is being done. Next, they assure that the rights of being informed about the proceedings, right to protection and speedy justice, right to present arguments and written submissions, examine witness, to be heard at sentencing, and right to be restituted, all shall be enjoyed by the victim. Now, in this point of time, I am reminded with a very interesting question for you all, that if at all a victim is a poor person, or the victim is too poor to take up the case and to bear the financial expenses of this particular case, if at all, do we have a provision in the Indian system, under the constitution, under any criminal system, for us to say, wherein we might be providing some kind of free legal aid? If yes, say yes in the comment section, and also give me the exact article of the Constitution of India that gives us this right. Let me know. So ultimately, this article says that this will have an indelible impact on the way we perceive our criminal justice process, and thus we need to make sure that the victim is at the heart of the entire procedure. With this, let's move further with the news updates. Firstly, Pandit Shivkumar Sharma passes away. So, legendary santoor player Pandit Shivkumar Sharma, who gave the little-known instrument an exalted status with his art, died of a heart attack in Mumbai. The Jammu-born artist was 84 at age. So this you can remember that Pandit Shivkumar Sharma was associated with which of the following arts? So it was music, and music, basically there was an instrument called as santoor. Secondly, Army Chief gets Param Vishisht Seva medal. So days after he assumed the post of the Indian Army Chief, General Manoj Pandey, on Tuesday was awarded the Param Vishisht Seva medal for distinguished service of an exceptional order. The honor was accorded to him, of course, by the President of India, who is Ramnath Kovind. Thirdly, Marcos Jr. wins Philippines presidency. So the namesake son of late Philippine dictator Ferdinand Marcos has now been elected as the Philippine president by a landslide, in an astonishing reversal of the 1986 People Power pro-democracy revolt that booted his father into global infamy. Fourthly, National Technology Day. So with various advancements in the sector, India has climbed its way up in the list of countries that are potential superpowers in the coming future. So India celebrates the National Technology Day today, that is on May 11th, as it was on this day in 1998 that the country successfully conducted the famous Pokhran nuclear tests. Fifthly, Thrissur Pooram, held after 2 years. So the Thrissur Pooram is basically an annual temple festival which is held in Thrissur in Kerala, India. So it is held at the Vadakunnatham Shiva temple in Thrissur every year on the Pooram day. So the day when the moon rises with the Pooram star in the Malayalam calendar month of Medam. It is the largest and most famous of all the Poorams in India. So Kerala's iconic festival, Thrissur Pooram, was held with all the grandeur and gaiety, with a parade of Richie. It was basically a grand celebration. And please remember that this Thrissur Pooram festival of this festival, or this temple festival, is conducted in Kerala. Sixthly, RailTel launches PM WANI. So RailTel has launched Pradhan Mantri, or the Prime Minister, Wi-Fi Access Network Interface. Now here this full form becomes important for us to note, that what is the full form of PM WANI, or what is it associated with. So please remember that the full form is Prime Minister Wi-Fi Access Network Interface. And what is it related to? Of course, it is related to the Wi-Fi connections. So this scheme based access on its public Wi-Fi services across 100 railway stations, the Rail PSU said in a statement. Now let's see that what do we have for the legal news for the day. Firstly, certificate under Section 65B Clause 4 of the Evidence Act is mandatory for production of electronic evidence Oral evidence cannot possibly suffice, says the Supreme Court in the case of Ravinder Singh Kaku versus State of Punjab. So the Supreme Court has held that in order to produce electronic evidence, it is mandatory that a certificate under Section 65, Clause 4b of Evidence Act is issued. Oral evidence in place of the certificate shall not be deemed to suffice. Secondly, time limit for filing of a written statement under Order VIII Rule 1 of CPC, that is Civil Procedure Code, is not mandatory, says the Supreme Court in the case of Bharat Kalra versus Kishan Chabra. So the Supreme Court has once again reiterated that unless it is a commercial suit, the time limit for filing of written statement under Order VIII Rule 1 of CPC is not mandatory. So this was all for the day. If you like this, do give it a thumbs up. And also I would like to make an announcement over here that based on this newspaper analysis, every day we shall be giving up, we already are, and now also we shall be giving up a daily quiz at 8 a.m. in the morning. So a Google form link will be shared with you all. If you're watching us through YouTube, please guys, you can consider joining our Telegram channel. The link is there in the description box below. And you can join the Telegram channel, and a quiz will be circulated every morning at 8 a.m., which will only be valid till 11 in the morning. You can take part in that quiz. It's free of cost. Absolutely, you can take part into it. And there will be 10 MCQs based on this particular newspaper analysis. So this will be like a revision for all of you guys. On that note, let's end today's discussion. We hope you liked it all. If you did, please give it a thumbs up. You may also subscribe to our channel for such more updates to come. Thank you so much.